Yeah. Well, welcome to Washington Arbitration Week. This year we have been a little bit sharper on starting on time, so we're only 1 minute or 2 minutes after the hour. So we're really excited about this panel, and I apologize for repeating over and over and over my name, but each panel is a different beast. So my name is Jose Antonio Rivas, and I am one of the co-founders of Washington Arbitration Week 4 years ago. I am both a Georgetown adjunct professor on investment treaty arbitration and also a partner of Extragy LLP, which has offices here and in Bogota doing investor state arbitration, commercial arbitration, and public international law. This is one of the panels that comes very close to our sort of ethos of trying to be faithful to the international rule of law, and also trying to do some broader community and social work in terms of expanding the international rule of law as vastly and broadly as we can. And so, as you can see, and as you know, Washington Arbitration Week is free of cost, not only for those attending in person, but also for those that are overseas and are unable to come to Washington, D.C. So I believe that we may have at this stage over perhaps 80 people together online and in person, which is a very positive thing, and they will keep on growing. But that would not be possible if we did not have sponsors that allow us for this venture to be sustainable. So I will take some time and thank our sponsors, starting with our host, Covington, and one of her or its co-chairs, Marnie Cheek, and also Shireen, who have both been staunch supporters of Washington Arbitration Week and our sister event, World Arbitration Update, which happens in May. I would also like to thank a list of sponsors, and bear with me, including Norton Rose, Fulbright, Burford, CRE, Greenberg Torig, HKA, Crowell and Mooring, Extragy, Miller and Chevalier, NERA, Wiley, White and Case, Allen and Overy, JAMS, Compass Lexicon, Baker Hostetler, Deckard, Cornerstone Research, Pillsbury, Three Crowns, Baker Botts, SRM, the Mintz Group, Aaron Fox, PwC, Gallagher, Steptoe, and Sougeron. Now, I would like to turn to the presentation of our moderator. But before that, and going back to the theme of Ukraine, by sheer luck, we were committed to Ukraine way before that the invasion of Ukraine took place. In fact, in World Arbitration Update 2 or 3 years ago, we had a first panel involving Ukraine on a comparative analysis of enforcement of arbitration awards in places that are not necessarily the centers or the epicenters of international arbitration. So at the time, we had Ukraine, how to enforce an award in Ukraine, how to enforce an award in other places of the world, and then a few months later, the invasion happened, etc. So with this panel, it will be perhaps the fourth panel where we try to give or put some light on the Ukraine situation. And one of the constant beliefs is that when the invasion happens and when there are so many events, the light, they have the spotlight, but part of the little support that we can give as a forum is to make sure that the issues, the spotlight is always maintained, regardless of the fact that there are many other issues in the world that are of concern, of course, the war in the Middle East, etc. But this is one issue that concerns us very much. So with that, I would like to share a few words about our moderator, Marnie Cheek. As I said, has been a very strong supporter of Washington Arbitration Week. She co-chairs the Covington International Arbitration and Dispute Practice and has advised companies, non-governmental organizations, and government on high-stakes international disputes and legal strategy for more than 20 years. Her work draws upon her expertise in public international law, investment, and international trade. She serves as both counsel and advocate before numerous international arbitration tribunals and courts, including the ICJ. She currently represents the government of Ukraine in its landmark cases before the International Court of Justice adverse to the Russian Federation, including allegations of genocide under the Convention on the Prevention and Punishment of the Crime of Genocide. And in addition, she has also been an investment treaty, an international commercial negotiator in the past, and she has represented parties before the major arbitration institutions. I could keep on going, but I know that might make her uncomfortable, so I'll stop there. Marnie, thank you for having us, and the floor is yours.
Thank you, Jose Antonio, and thank you for all the hard work that you've put into Washington Arbitration Week. It's a big undertaking, but you're always well organized and put together a really interesting program. So thank you so much for all your work and for your kind introduction. So we're here today. Thank you for joining us. It's great to see so many people in the room and online. We're here today to talk about the Ukraine crisis and post-war scenarios. You've heard a little bit of background about myself. You'll see that I thought, well, if our topic is Ukraine, I would take the opportunity to wear my Ukrainian colors today in light of our topic. And I would just add that Covington is thrilled to be once again sponsoring Washington Arbitration Week. So welcome. Let me introduce you to our three experts who are joining us for this discussion. And we hope to have an interactive discussion. I'm going to pose some questions to our panelists, and then we can open it up for questions. Let me actually start with our panelist who's online, Luke Kocienski, who you can see on the screen, is snowed in Western New York. So we appreciate him making the effort. Thank you, Luke, for joining us remotely at the last minute. Luke is a special counsel at Pillsbury Winthrop, and he is a Russian qualified barrister who's worked in Russia for 10 years. He represents multinational companies in cross-border disputes, and he has extensive experience representing U.S. corporations operating in Eastern Europe. He's also led business and legal and audits, including in the areas of anti-money laundering and bribery. At the end of the table, we are joined by Shashank Shetty, who is our non-lawyer on the panel. We always welcome those. Shashank is the EMEA forensic co-leader at PricewaterhouseCoopers, PwC, and leads the PwC Dispute Advisory Center of Excellence. Shashank has over 30 years of experience and has prepared many expert reports for international arbitration tribunals across the globe, including in Central and Eastern Europe. And he's been involved in commercial cases, investor state cases, and also in criminal proceedings. Last but not least, we are pleased to be joined by Jean Bird, who's a partner at Fisher Broyles. Jean has over 20 years of experience handling cases involving enforcement of foreign judgments and international arbitral awards in the U.S. courts, asset recovery, and as well as cases under the Foreign Sovereign Immunities Act. Jean has represented clients in international arbitrations and also served as an arbitrator himself in commercial disputes. Jean is fluent in Russian, conversant in Ukrainian, and as we were just sharing before the panel, however, is not currently traveling to Russia. So I thought I would just provide a little bit of scene setting. I can see by the folks in the audience, some are very well steeped on these issues related to potential post-war compensation for Ukraine, but others also might be newer to the topic and interested in learning more about it. As we approach the 2-year mark of Russia's full-scale invasion of Ukraine, which happened in February 2022, increased attention is really being paid as to how Ukraine will recover and will rebuild, really with the assistance of the rest of the world following the war. And while some of the legal discussion regarding the war in Ukraine really has focused on the international humanitarian aspects of the war, Russia's violations of international treaties, such as the Genocide Convention, in the case that was mentioned earlier. Today, we want to focus on private rights of action for damage caused by Russia during its invasion of Ukraine, how those losses can be quantified, and whether Russian funds, which are currently frozen all over the world, can ultimately be used for compensation for those who have suffered those losses. This is a very dynamic topic. There's a lot really happening to move the discussion forward every day. And I'm delighted to be joined by 3 folks who have a lot of experience and expertise to add to the discussion. I would just add, as a frame of reference, last March, the International Financial Institutions and the United Nations estimated that Ukraine had already suffered about $411 billion of damage, and that was just in the first year of the war alone. And really no industry has been spared. This relates to housing, transportation, energy, agriculture. So you really are looking at a big reconstruction effort and a number of Ukrainian and other enterprises who have claims for losses against the Russian Federation. So with that, I think we'll start to the questions and hopefully have a robust conversation about how to move these issues related to compensation and rebuilding as we move forward. So Luke, let me start with you since you are our remote participant. As I just mentioned, obviously many companies have seen major losses due to Russia's actions in Ukraine. I wonder if you might speak a bit to what type of claims are possible to recover those losses, and then also of interest, kind of what is Russia doing now to try to defend itself against these claims?
Sure, yeah, thank you, and thank you again, and my apologies for not being able to be there in person. You know, Russia's invasion of Ukraine has certainly led to significant economic repercussions, as you mentioned. And that has prompted the U.S., the EU, its allies, to consider various legal frameworks for compensating those that have been affected. Obviously, the key question in relation to any claim is whether and how you're going to be able to enforce that claim. And so that's where you need to start. One key issue here, which may not seem that important at first, is the economic sanctions that have been imposed on Russia, Russian individuals and Russian entities. And why is that important? It's of course impossible to predict how or when the war in Ukraine will be over. But at some point, it is possible that Russia will be looking to remove those sanctions, and provided that there is a political will at that point on this side, one of the criteria for their removal should be certainly the use of those blocked and frozen assets to satisfy economic claims against Russia, but also the ability to enforce commercial claims against Russian parties. So those two key questions really remain undecided, how those claims will be adjudicated, where the funding to satisfy them will come from. And they do go hand in hand. So the first step, we've seen countries taking that first step, which is a process for registering claims for a future time when there will be a proper adjudication process and an understanding of funding. The most prominent of those is of course the Council of Europe's Register of Damages, which was announced in May of this year, signed by the EU and over 40 other countries. This provides the initial framework for the identification and registration of claims against Russia by individuals, companies, and governments as a result of the invasion of Ukraine. And it's important for anyone with a claim to begin with this process as soon as possible, which I'm sure we'll be speaking about later on the panel. There are some other measures, other countries. We're aware that Canada has taken the lead in seizing and pursuing the forfeiture of Russian assets, including those owned by any national of Russia, with two cases that I'm aware of, including that the Volga-Dnieper airplane that was so prominently parked at Toronto's Pearson International Airport, if you've ever been there in the last couple of years. So with that as a first step, there remains a lot to be seen in several potential options for the adjudication process. The international commissions or tribunals under the auspices of the UN, which is difficult to see now due to the veto right of Russia. But again, it's so difficult to predict the future. Bilateral ad hoc multilateral agreements, such as the Iranian States Claims Tribunal, and probably most likely single country administered processes under domestic law. Ukraine has probably taken the lead on this. The Supreme Court, I know, rendered a few judgments declaring the absence of Russia's sovereign immunity in a civil tort cases. But that's actually quite controversial in Ukraine, I understand, and so we'll see how that develops. And of course, there is the enforcement issue as well. But really, the strategy that those who have suffered losses will need to consider, various jurisdictions, monitoring the potentials for all of the types of claims that they may be able to submit. As far as Russia is concerned, it's easy for us to get caught into a pattern where we think about what it is that we can do on this side of the dispute. But Russia is continuing to look at the developments. They're very well aware, and are taking and will continue to take measures to counter any possible claims and the potential for future claims. With the examples of what I was speaking about, those Ukrainian civil tort cases, you can already see that there's the attempt to formulate a position for several years down the road. They're not attending the court hearings. They've made statements that there are no diplomatic relations between Ukraine and Russia, so they don't have the ability to defend themselves in those cases. And if we use other things happening as a bit of a framework, we see that Russians are going to continue to adapt. They've adapted to sanctions. The measures that they've taken to foreign investments in Russia have always had an eye on BitClaim cases to avoid any sort of potential expropriation claims, or at least to complicate those cases. If you look at the several examples, the aircraft, we all know aircraft were seized in Russia, and the Russian government didn't just re-register them. They took a blind eye to where those aircraft were registered previously so that the owners could register them. So Sakhalin is another good example where they're not actually taking away the assets, but they're permitting the assets and the shares to be transferred into Russia to domestic jurisdiction. So with all of the actions that are taken over here, it is important to see what Russia is doing, because they will, in my opinion, they will fight any claims in the future, even if there is some sort of agreement down the road. Yep.
Luke, before I move on, if I could actually ask you one follow-up question. You're our only Russian qualified lawyer on the panel. And I think the conventional wisdom would be that trying to seek redress from the Russian courts for damages suffered in Ukraine would not be a path to success. But I'm wondering if you agree with that conventional wisdom, or you think that there may be, for some types of cases, some avenue of redress within Russia itself.
Yeah. I'm going to take the long road to get to that answer, because while I think that the short answer is most likely not for most cases, there may not actually be a choice by the non-Russian party. As could be expected, Russian courts have taken, in my opinion, several steps back in their independence and professionalism at the expense of non-Russian parties in those types of cases. I personally think that there was a time when the high level of corruption in Russian courts was being reduced. And I think that there's always been a political component to the most high profile cases, but you were seeing a system that was developing that allowed the majority of cases who are not as high profile to be able to progress with a better chance for a positive outcome for the non-Russian party. Since the invasion of Ukraine and the imposition of sanctions, that's seemingly gone by the wayside. And now, instead of it only being high-profile cases, you see the type of decisions being made with a political angle that's happening not only in the general jurisdiction courts, where you have the cases against artists and protesters and oppositionists, but also in the state commercial system, the arbitrage system of courts, and the constitutional court, which is set up to ensure that the government and the law is complying with the Constitution, has been of little importance for many years now. So on the one hand, you think there's really not much to look forward to for a non-Russian party that is looking to seek redress from the Russian courts. That being said, like I said, in a lot of the cases, the non-Russian parties may not have much of a choice. And this of course depends on how things will develop. But currently in commercial claims, including commercial arbitration, the Russian state commercial or arbitrage courts are consistently grabbing jurisdiction of claims where there's a very straightforward foreign non-Russian arbitration clause. This goes back to 2020 before the invasion, but obviously this came about after the 2014 invasion of Crimea. And what the courts have done, they have a law that was passed to say that Russians don't have equal access to defend their rights in commercial arbitration cases abroad. And so if they are sanctioned, or the dispute is more or less sanction related, which has been very widely interpreted, then the Russian state commercial courts have jurisdiction over that dispute. So you have a number of situations where there's a viable arbitration clause, but Russian parties have decided to pursue the dispute either to stop the arbitration, to prevent the enforcement, or to try to get after assets of companies that are that have assets in companies in Russia or in countries that are signatories of the Minsk Agreement, where Russia could potentially enforce, where these cases are moving forward, even though there was an arbitration clause. So the Russian government will continue to try to find ways to protect the interests of Russian parties. And unfortunately, the Russian courts right now may be the only option for defending your rights, even though that's not the desired option. We'll see how that goes forward, but I don't expect that the Russian government will lie down and let a lot of the claims go out without some difficulties, similar to what we're seeing now with the commercial arbitration.
Thanks, Luke. Yes, certainly.
Yes,
Jean?
that's actually, the question was really interesting because probably about 15 years ago, 10 or 15 years ago, we had a case where we were enforcing arbitration award, the Stockholm Award in Russia, against a company that was closely affiliated with a Russian Moscow municipal government. And we've been successful after 5 or 6 years of litigation, which went up 3 times to the Supreme Arbitrage or High Arbitrage Court, what it used to be back then. And eventually we're able to transfer significant sums of money based on these judgments out of Russia in the United States to the client. But I just don't see how it would be possible right now under the present political leadership in Russia. So unless the political leadership would change, it's probably not likely to be happening anytime soon.
Thanks, Gene. So based on that outlook in the Russian courts, I think it sounds like Russian courts would not be the first choice. But what about the U.S. courts, Gene? Because a lot of claimants are going to look for ways to use the U.S. courts to try to get redress or enforce judgments against Russia.
Yeah, now you come to the elephant in the castle, right? The foreign sovereign immunity. Of course, if somebody wants to bring a claim, whether it's by way of enforcement or a direct claim in the United States against Russia, against the Russian sovereign, on one hand, you have a pot of about $300 billion of assets in the United States that have been frozen by the U.S. government. There's a central bank asset that potentially a good target for recovery. However, of course, because of the foreign sovereign immunities, there are very narrow exceptions that any claimant would be able to use. And from another side, there are 2 levels of sovereign immunity. There are two prongs to the sovereign immunity. One is the sovereign immunity under international law, and another one is sovereign immunity under the U.S. law. And they would both need to be taken into account if you want to pursue action. Under the U.S. law, there are probably three most likely exceptions that could be used for the immunity. That one is the arbitration exception, second is the waiver exception, and the commercial activity exception. And lastly, of course, the expropriation exception, that the fourth one could be used in some cases. All of this exception, of course, the arbitration exception would apply if you want to enforce arbitration award. If a claimant obtains arbitration award, the arbitration exception would be the most direct way to enforce this award in the United States under the Foreign Sovereign Immunities Act, which is the sole basis for obtaining jurisdiction of the foreign states in the United States. Even if a claimant brings a claim in a state court, it would be removed. Could be easily removed to the federal court in the federal court. There was interesting case was recently decided by the Supreme Court. That's the Gazarian case with Osmagin. It was decided in summer of this year, where the efforts to prevent enforcement of the arbitration award were treated as nexus, at least the possible nexus to the U.S., to the United States for the application of the RICO law, which is a racketeer influence corrupt organization law. That is sort of another way to look into that. So if there are, for example, if there is a valid claim and if there is an arbitration award and a judgment that was obtained based on that arbitration award, then RICO might be a way to bring additional actors in this action, because in RICO very often you have conspiracy claims, you have conspiracy allegations, and that's something that could be considered. So it's not only Russia, but other parties. So, for example, rich Russian oligarchs with assets that have been frozen or located somewhere else outside of the United States. But these are all the cases where you need to consider specific facts and circumstances in order to really to lay out the strategy and the trail and how to get to the assets and how to avoid the just straightforward application of immunity. So waiver exception, that's certainly one other way to proceed. And Some courts applied waiver exception in cases involving enforcement of arbitration awards or even judgments that are against foreign states. So that's something that would need to be considered. The last one, I mentioned about the expropriation exceptions. The expropriation needs to be against international law. And U.S. courts actually, they adopted the application of what is violation of international law from the ICJ decision in the Germany versus Italy, which basically held that the gross violations of serious violations of humanitarian law do not provide exception from immunity. So from that standpoint, we need to find additional arguments to see how that specific exception can be applied.
Thanks, Gene. So I think we've mapped out that choosing a legal path can be complicated, but of course, there's also an additional complication, which is how you really make your damages case in the first place and how you can figure out how much compensation you might be due so that you actually are a lucky one who has a claim, a specific claim to be able to try to get paid or enforce against Russian assets. So Sirshar, I thought you might help us kind of take a step back and be thinking about, I mean, from a practical perspective, what are some of the challenges you see and what does the evidence look like to support some of these damages claims that are coming out of the war in Ukraine?
Thank you, Marnie. And first of all, I'd like to take the opportunity just to say thank you to the organizers for Washington Arbitration Week. It's my first time here, and I'm very impressed, I have to say. There's been some excellent speakers yesterday. I'm very in awe of my speakers I'm working with today. So well done, and I'm looking forward to the rest of the week as well. And thank you, Covington, for hosting us today as well. So, I mean, I'm based in Prague. I know I don't look Czech, but I am based there, and I cover our Central Eastern European practice for PwC from a forensics perspective and dispute perspective. That includes Ukraine. I would say the last, just less than 2 years now, I've been heavily involved with our practice in Ukraine. I would say that they are fully functioning even since the war started. We have a practice of 400 partners and staff there still operating. They're fully fledged, helping clients there on the ground. And they're offering the full services, like audit, tax, et cetera. So I'm very impressed with, I'm very proud of my team there because they're working and they're getting on with it. And I would say the definition of resilience, absolutely. Soon after we sort of started looking at what was happening and the war was continuing, one of the first things we did was set up a loss assessment center in Ukraine with our forensics team there, primarily because we didn't know what was going to happen. And we're still 2 years later, still not sure what's going to happen. And I'm hearing still lots of complexity around the legal jurisdictions in terms of what may happen, in terms of from how even claims can be, enforced, obtained, et cetera. So we thought it was a good idea to maybe set up a center where clients and corporates can come and see us and talk to us. So with that in mind, I mean, one of the questions is why do anything now? Why look to damages when a lot of things are just not clear in terms of process? It's true. I mean, but I have to say from experience, preparing a quantum claim is not easy. There's lots of evidence and documents you need. And obviously, first thing you need to do is obtain those documents. And even with companies not in this situation, it is a challenge. But here, I think we are talking to companies and they want to be prepared. They want to be prepared for what happens next. Now, we don't know what it's going to look like. Is it going to be through US courts? Is it going to through bilateral investment treaty? Is it going to be through some claims commission? Don't know. But one thing that they do want to know is in terms of what is it likelihood that they can claim and be prepared for that. And in order to build the building blocks of a strong claim, you need to have evidence and documents. So I'm not going to underestimate the level of what needs to be done for that from that perspective. And a lot of the clients approaching us, I mean, this is uncharted water. They don't want to be dealing with courts and claims. It's not what they wanted to do. They want to do business, and they want to get the businesses back off the ground. They want to continue working. So obviously, we're more helping and guiding them in terms of what needs to be done. So that's very much the anticipation in terms of getting the business going, what needs to be done. And also, I mean, there's odd questions that come at, you know, the reasons why companies want to do something now. It could be, say, if it's a subsidiary of a parent company somewhere else, Ukrainian subsidiary, they want to sort of just understand, well, what may be the rebuild cost? If they decide to pursue a claim, depending, knowing how that will be done, you know, can they claim loss of profits? Can they claim, you know, direct damages? You know, what is it that they can claim? Now, I'm not the one to answer the nexus of where they can claim and how they can claim. Most of the time, they don't have lawyers involved. They're just asking to pull the documents together. But it's like the hope that, okay, something will come out. And as you can hear, there's lots of hard work going on in terms of working groups and registers being set up in terms of what may happen, but certainly to be ready for that point in time. So maybe just talking a little bit about the types of documents that we made, you know, and this is just being practical here. I'm not going to give you a full list of everything that's needed. But certainly, you know, things like accounting records. I mean, these are things that you need to expect in management accounts, financial accounts from the past. And companies are still churning these over because they are still spending money on things. I know it's hard to believe, but yes, there are things going on. You know, different businesses are affected in different ways. Things like damage of property in terms of technical construction surveillance reports. Costs incurred because of the invasion in terms of employee relocation. For how long do they continue paying their staff, their key staff? Yeah, are they mitigating their costs or not? But obviously they need the staff because they want to continue being loyal to their people. When electricity goes down in terms of, say, electricity shutdowns, do they have generators and how to keep businesses going as they are? So there's these costs and these need to be documented. They need to be evidenced. Now, at the moment, that's sort of one set. The other one is obviously, what is the business plan? What will happen next? We talk about scenarios, but in terms of, okay, let's assume the war ends tomorrow. Then what next? Yeah. In 6 months' time, 12 months' time, they'll get the business going. What needs to be done? I mean, we've had different companies approaching us, but like, for example, things like, you know, demining costs, for example. You know, these are the things that can happen, and certainly in order to rebuild costs, etc. The other factors around, say, contractual penalties and these sort of issues also need to be considered. So that's it in terms of sort of companies that may have been damaged, but also there's the other businesses that they're not in control of the businesses. They're in the occupied area. So in terms of what happens there, well, you know, certainly completing a complete list of inventory of what they had there, what the value may have been, what the value was at certain points in time. So there's a lot in there. And ultimately, it needs to be considered under whatever legal nexus may happen next. But I think in short, it's about being prepared.
Thanks, Yashar. So we have a legal pathway. We know that there's something you can do now, which is try to figure out kind of what your damages have been. There's another issue I thought it would make sense to address, which particularly here in Washington is a hot topic of conversation, and that is there are these sovereign frozen assets that were referred to earlier, and they're hard to attach even if you do have an award. I was wondering, Jean, I know you've been following some of the legislative developments in the US Congress related to the possibility of using those frozen sovereign assets to satisfy claims. And I wonder if you might speak a bit to where you see that kind of legislative process right now.
Sure. Well, the good news is that you have uniform support of Ukraine on both sides of the spectrum, putting aside just some insignificant minority, again, on both sides of the spectrum. And the administration was also very supportive of the Ukraine efforts to defend itself, of course, and to ability to provide for their construction, the funding for their construction of the country. There were a proposal from the U.S. government, from the Biden administration, that was to mostly focused on the efforts by the Department of Justice to obtain funding from various sources, not necessarily from the frozen assets, but also, for example, from the assets of the kleptocrats, what they call kleptocrats or oligarchs, to obtain these assets from either from those that been frozen due to sanctions, and then to confiscate these assets and to use them for the to put in the compensation fund. And again, this fund would be either by way of some type of claim commissions, whether it would be, there are a number of different proposals right now been floated in the academic institutions as well as on the Hill regarding how this type of compensation can be structured. The other venue been discussed is clamping down on facilitation of sanction evasions. Any entity that would be found to be violating U.S. sanctions, its assets that could be used to, again, to put it in the fund to compensate the Ukrainian entity, Ukrainian government, or private actors, whatever again, it's all in the process of development. The other is, I mentioned before about Racketeer Influence Corrupt Organization Act, and that was on the side of civil claims. But now the United States government also wants to include, or at least considering including violation of sanctions as one of the predicate acts under the RICO law. That would allow, and again, it's unclear at this point whether it would also allow private cause of action or only from the side of the government. But that would be another possibility to confiscate assets eventually that would be used for Ukraine. There are some other proposals from the U.S. administration, from the Senate, and there is also a joint bill, the Senate and the House bill. As you know, many of us, I'm sure you all know, but the bill has to pass both chambers, the Senate and the House, in order to become law. So there is a joint proposal called the REPO Act, R-E-P-O Act, that was introduced by both parties, both in the Senate and in the House. So it's a joint bill which moves in parallel. Last time I looked at it, was no committee hearings on this bill that was introduced. There was some preliminary, it was read twice. But doesn't look like there is a very active movement on this bill. Probably people on the Hill are busy with some other issues that they consider more important, but nevertheless, that's an important step forward to have this bill introduced and considered. And the idea of this act, the objective, the goals of this legislation is to give the president the authority to confiscate Russian sovereign assets that have been frozen in the United States and transfer them to assist the Ukraine reconstruction efforts. Again, there is very little details at this point how these assets will be used and where they will be transferred. Department of State will probably play a role in that. It's unclear at this point. I was trying to see if there are any developments as far as to provide additional exceptions to the foreign sovereign immunities. I couldn't find any direct proposal on that. Maybe in the process of the deliberations on this type of legislation, there will be some amendments that would allow private cause of action. But so far, most of the efforts on the congressional side are focused on providing the U.S. government or some type of international bodies or tribunals or organizations with funding to create some, perhaps a tribunal, some like you refer to Iran tribunal, or some type of compensation commission that would consider these claims, which sort of will bring back these private claims. But the question is which form these claims will be brought, whether they will be directly in the U.S. courts or through the commission that, through the claims commission that would have enough sufficient funding to provide compensation.
Thanks, Jean. And what about in Ukraine? Because I've heard that Ukraine is also undertaking legislation to be able to strip Russian assets of sovereign immunity.
That is true. There is actually the court case that was recently decided, or last year decided in Ukraine, where the Supreme Court, the Ukrainian Supreme Court, they held that there is no sovereign immunity for violations of international law. However, as we know, Ukraine is not a common law country, so this one court decision is not necessarily, does not create a law in Ukraine. And that's why there is a legislative action that is required on the Ukrainian side. And indeed, there is a law being deliberated in the Rada that would allow stripping Russia from sovereign immunity in connection with any claims relating to the Russian invasion and Russian aggression in Ukraine. Well, one issue that I'm personally involved, one issue which is what type of notice is required and how this notice can be made and how the Russia can be served in this type of claims. And because there were attempts of a number of claimants in Ukrainian courts to serve Russia as required by Ukrainian legislation in cases of involving foreign states. And of course, Russia, in many cases, they simply ignored this. In some cases, they simply returned the court papers. So, I mean, you can imagine in the previous in the current political situation, the Ministry of Foreign Affairs would somehow accept service of a claim against Russia in Ukrainian court against the Russian Federation. So that's highly unlikely. So it needs to be some other mechanism to allow service that would be, on one hand, legal under Ukrainian law, and then on the other hand, recognized by the country, for example, by the United States, if the judgment that is based on such claim is brought against Russia in the United States.
Thanks, Jean. So actually, Saoirse, going back to the damages aspects and the complexities there, you know, I was thinking about what you were saying about how like the different types of documentary evidence you need to be able to build a case, the fact that you have people on the ground, the fact that Ukrainian companies are engaging with you. But do you think, just putting your expert hat on, that you're really going to be able to get all the evidence that you would need, say, regarding, you know, losses in temporarily occupied territories? Or do you see that whether there's a compensation commission or individual arbitrations that are brought, do you think that there's going to need to be some kind of flexibility on the tribunal's behalf in looking at these damages issues because just of the complexities and in some case maybe inability of gathering evidence? I'm just wondering if you're kind of seeing that down the road, or if you think actually, no, it should play out the way it has in other cases.
That's quite a tough question, because I mean, I can answer it from a perspective of a classic situation. So not a claims commission, maybe a classic situation of a tribunal. Okay, what do they need? So I feel my job as an expert is to prime them with as much evidence as is available practically. I mean, I appreciate we may not have everything, but like, for example, if we were assessing a loss of profits assessment, you're looking to assess it as probably everyone knows, you have a but-for scenario counterfactual. And then you deduct that from an as-is in terms of what is happening. Now, the counterfactual starts from where? Does it start from the beginning of the war? Does it start from when the business was somehow interfered with in terms of from a missile perspective? So there's a few questions in there, and what I think what we can do as experts is maybe run those scenarios depending on which way it's going, unless we get clearer direction. So that's maybe one way we can help. So again, saying, okay, let's assume there'd be no war. Okay, how things would have projected. Okay, there's some assumptions in there, some forecasting. Won't be easy, but we'll try and come up with something that makes sense, reasonable, and as supported as it can be. if it's in relation to a missile or damage, okay, how did that affect it if that's the cause of the damage, that needs to be compensated. So that's sort of one thing. Again, complexity, difficult, but as much as we can do. And then the other side of providing scenarios is, well, in the as-is scenario, which is what is actually happening, well, at what point in time are we? If we're at a point in time where the business is flourishing and moving on and everything's done, well, that's easy then it's the cost to get to that point, and then for the business to move forward, assuming if it's in the same state or different state, but so that's easy. Or is it done beforehand? In which case we're having to project again. We're having to project, well, what is the as is? How long, if the company was to put an alternative business plan into place or a scenario in terms of what may happening, then we can try and assess that. So will the ball finish 1 year's time, 2 years' time, 3 years' time, and then project from there? Again, it just causes uncertainty, but I think what we can do for it as experts or the tribunal is put those assumptions down, and then the tribunal will play with it. Again, I'm looking at a lot of uncertainty at the moment, so a lot of projections, maybe things will get clearer as we move forward, and I hope it does. But that's sort of one way of looking at that side of things.
I have a follow-up question, if you don't mind. We see some cases right now where there are commercial disputes involving force majeure that is caused by of course, events in Ukraine, and there are parties from different countries, from different jurisdictions. Some of them may be Ukrainian, some of them maybe not. How would you assess this situation from the damages perspective?
So maybe just clarify the situation. So it's force majeure.
For example, there is a construction project in Ukraine. And some of this, and even if it's not necessarily in the occupied zone, the ability of the parties to continue with this construction project is impeded because of the Russian invasion. So how would you assess the damages in that particular scenario? Would that be a conventional type of analysis, or would that analysis be impacted by the force majeure itself? Whether you would consider the fact that there is an invasion in computing this type of potential recovery by any of the parties?
Yeah, well, the starting point for me is always the lawyer in terms of what are the instructions we're making. You're asking us to assume. I'd always bow out that way. So if the assumption is, if the instruction you're giving me is force majeure is caused by Russia, they've caused the situation. Now, what is the loss? And now the loss is to whom? Who's incurred the loss? Because I assume there's two parties to the contract. They've incurred the loss. So I suppose that's how we would assess it. If that's the instruction that you're giving us, you're saying, assuming force majeure caused by Russia, and then those parties to the contract will be taking a claim under that contract against Russia, I assume.
Jean, I think you're going to have to enter into a contract with Saoirse to get a more detailed advice.
We're fully available, so we can have a chat afterwards.
Fair enough.
Let me just ask one more question of Luke. Sorry, Luke, we've left you in your snow on the video line. And then we'll open it up for questions. So if folks have questions, they can come forward to the microphones. But just to ask one last question, Luke, our entire discussion pretty much has been framed as Russia being responsible for loss and damage, and how the various legal paths available, the challenges involved, both on the quantum side and the legal and sovereign immunity side. But I was wondering, just in terms of commercial disputes, where also, Russian parties may have been affected by the war as well. Do you think Russians will also be filing kind of commercial claims, and how are those being handled? And in terms of cases where Russian companies are defending those commercial claims, how those types of cases are playing out?
Yeah, I mean, the answer is yes. I do expect that. It's difficult to predict where this is all going to end. But the environment right now is one in which, you know, there are many factors that point to Russian companies continuing to be aggressive as soon as there's an opening that potentially they understand that there might be the ability to enforce abroad. Let me give an example of the aggressiveness. You have a lot of Russians right now who are challenging sanctions designations in cases that have not been very successful on their side. So there's a lot surrounding them. Obviously, a war is a difficult situation. If you put your sort of yourselves in the position of the Russians, the companies are not doing well economically. The Russian economy, no matter what the Russian government has said, has been hit hard by the war. Yet there still are a lot of assets, a lot of funds to go after foreign companies. There is an understanding that sanctions have hit, and maybe that was unfair to certain parties. There's oligarchs that have tried to distance themselves from the Kremlin or from Russia, who are still tied up in sanctions. And then, of course, you have a lot of very experienced arbitration specialists in Russia who used to work for foreign companies, but still have a lot of experience working in commercial international arbitration. So no matter how this conflict ends, it seems to me that we're right on the precipice of a whole number of disputes that are going to be coming from both sides, similar to what we saw after 2014. Those would be contractual, like Gene was talking with the force majeure, not only in Ukraine, but also in Russia. The Ukrainian and Russian economies are so connected that there's bound to be supply chain disputes. Let's look at the nuclear industry, and you have nuclear power plants where they're not just getting it from Rosatom, but all of the turbine blades and everything else that needs to be developed. There's IP rights that are held by Russians. There's contracts to supply parts that are held by Russians, and we can expect that those are all going to be canceled in the future. So a number of contractual disputes, investment claims, so investors from outside of Russia who feel that their assets have been expropriated, but also Russians who feel that there's been expropriation by the West, depending on what happens based on this conversation. Insurance claims, plenty of insurance disputes coming forward. So yes, we can. I think it's a little early right now to really say we're in the thick of it, but at some point we will get to that point where companies are going to start getting more aggressive. And then it comes to the question of where are the assets again, and who has access to them. So I think what's important to look at now is what is going to be the Russian government's role in those disputes. Are they going to continue to try to take measures to protect their companies moving forward, or do they have other different problems that they're dealing with? There's going to be jurisdictional challenges that they may be able to help out with. The applicability of sanctions that they're going to challenge. This force majeure under Russian law is something that is disputed. And then, of course, the sovereign immunity claim for any of the state-owned enterprises, which we know in the Russian economy is quite a large percentage. So it seems like we are in, I don't want to say the calm before the storm with commercial disputes, but we are on a precipice of a very active time. And I wish I could say when that was going to really kick off, because there's things going on now, but I don't expect the aggression to end with any sort of solution to the war.
There's conversations right now about this type of claims, but putting aside VATs, there are a number of claims under the gas supply contracts already been filed by Russian companies. That Gazprom was one of them. The others that pursuing claims against their European counterparts with respect to these, of course, sanctions. One of the key elements on defense. So it's a possibility. See how it develops. That's why we have these panels on Ukraine every year, and every year there is a very high interest in these panels because things are developing. They are in the very active phase right now. We're interested to hear what's going on. Maybe Marnie, you can also address that.
Any other questions? Okay, if not, I might actually ask a question to just wrap up. It seems like we talked a lot today about challenges, and I'm interested to hear kind of what your predictions are for how this all will unfold, and whether ultimately, either through private action or otherwise, you think that there, will be some form of compensation for those Ukrainian enterprises that have suffered considerable losses as a result of the war. Well, let's see, shall I go first?
Yeah, okay. I'll give it a go. I mean, first of all, I think the war needs to end. That's sort of the first thing that probably does need to happen. And then I suspect with all the work we're seeing by the donor organizations within Ukraine, I can imagine that they're focused on getting the infrastructure back up. And that would be the primary focus for them. I know we are supporting these donors in various cities across Ukraine in terms of assessing infrastructure losses. So that's sort of one thing that may happen now. The issue is around the corporates and what they've lost, what the mechanism will be. Will we have a claims process that will be set up? So therefore there'll be a pot of money. Then there'll be somehow there'll be some claims management process around it. That's one of them. We've things like that and all the other claims like that is going to be one big process to So I mean, I'm just being practical that around the claiming process could be the way forward, but I'm not going to put
my sense, and again, I'm just probably guessing more than anything, any prediction of that. But I'm very firm believer that there will be a compensation. It's hard to figure out, hard to understand what form and shape it's going to take. I mean, you look at the historical examples, some claims commissions. Even I read a few years ago that there were some claims commissions that existed for 50 or 60 years, even from the time of World War I. So it's a very slow process. So of course the victims, the damages, they need to be compensated as soon as possible. Of course, the first predicate would be for the war to end. So at least in the beginning, it will be some effort by the Ukrainian government itself with the help of the international allies to provide some form of compensation. And probably some type of a claim commission seems to be the more likely for at least for the individual losses or small business, medium-sized business. If you look at the larger type of companies, larger companies or international corporations, that they may undertake more private actions, again based on the bilateral investment treaties or some other type of treaties. But eventually, of course, it may take long time until these issues are resolved.
Thank you. I'll throw in my 2 cents too, do we have Luke, can you hear us or no?
I can, yeah. I couldn't hear Sushar, but I heard Jean, so yeah. To add.
I think we can actually.
Some type of law behind the sanction?
Sorry?
Is there some type of legal law behind the sanction?
Oh, absolutely. Absolutely, there is a international. There's a EE something. There's the Emergency Act that authorizes the President of the United States to impose sanctions. The sanctions is a very old tool. They've been used in the international law for hundreds of years, if not more. The United States is not the first one and not the last one and not the only country that imposes sanctions. So that absolutely, there is a basis in the US law and international law for the sanctions. The issue with sanctions is that they don't confiscate assets. They freeze assets. They don't change title. They don't transfer title. They don't allow anyone who may have a claim of damages against the sanctioned entity to obtain these assets to compensate itself or herself or himself or themselves. So that's the issue. You have $300 billion right now frozen of of Russian sovereign assets in the United States. That doesn't mean that they don't belong anymore to Russia.
Let me,
Marnie, we actually can hear Luke.
but only on your computer.
Yeah, but we have we'll do a connection here. So it's
All right, Luke, if you will indulge me as moderator, I'm going to decide that our IT challenges are such that I'm going to steal your last word. So, okay, cool. I would say, just going back to this final question, that I think the beauty of the international system is there's many, many paths to pursue, and all of these paths are really being pursued at once. So larger corporations that are capable of bringing claims now are going to bring claims now. They're not going to wait. The Registry of Damage is prioritizing individual claims so that those, smaller claims feel like they also have a place to go. And I think all of these things are going to continue to move forward at once, and ultimately will create kind of a complementary web of demand for compensation through rules-based mechanisms and due process-based mechanisms that ultimately will force compensation for the widest possible range of actors. So in that regard, I guess I'm an optimist, and I have faith in the system that it's providing multiple pathways to try to solve this complex issue. So with that, please thank our panelists, Luke from the snow, as well as Sirshar from Prague, and Jean from, where are you from, Jean?
No, I was trying to see if there are questions.
And Jean. Thank you, everyone.
Okay, you ask a question.
And we have seated you back for, we've seated you back 4 minutes.
see what goes on. So I don't know what the issue is, but they should be able to fix it. We have some time before next week.
Maybe there is like overlapping.
It's